Hello, Dehmlow Vessels, lawyer in Marietta, Ohio. Today we're talking about shut-in clauses in oil and gas leases. We've been doing a series of videos on oil and gas leases and when they expire, and we've also talked about a number of savings clauses, provisions in oil and gas leases that keep them from expiring. Now, a shut-in clause is a little different in that it's one of the types of savings clauses that will prevent a lease from expiring during the secondary term, after a well is drilled. The way a shut-in clause works is it allows the lessee, the oil and gas operator, to turn off the well. That's the literal thing that they do. Shut-in is just a fancy word for turning off. They turn off a producing well and then they pay a substitute royalty set by the contract during the period of the shut-in. Now, the reasons why they would invoke the shut-in is having to do with the economics of operating the well. Sometimes the price of oil or gas goes so low that it is not profitable to continue to operate during those periods. Sometimes they cannot get the product to market. They need to rehook up a pipeline. Sometimes they need to shut down to do needed repairs. But my experience over the last 4 years is that some of the lessees are abusing this clause. Here are some things to look for. How long is the shut-in? It should be specified in the lease. Sometimes it's 6 months, sometimes it's a year, sometimes it's 2 years, sometimes as much as 5 years as the limit of how long they can have the well turned off. My opinion is, although it's not been completely tested in Ohio, is that it cannot be indefinite. I do not believe Ohio courts will allow a lessee to declare an indefinite shut-in and pay substitute royalties for years at a time without limit. The other thing is, and it gets complicated, one of the questions is, does it appear that the lessee is attempting to use the shut-in clause to defeat the habendum clause? The habendum clause is the have and hold clause. That's the clause that says that the lease will perpetuate so long as oil or gas is producing in paying quantities. Well, all wells come to the end of their useful life, and they can no longer produce in paying quantities because they've run out of commercial volumes of gas or oil to produce, and so the lease ends. But some lessees will declare a shut-in, pay the substitute royalty. Now, in my opinion, that lease should have ended for lack of production in paying quantities. It's not a temporary shut-in in order to get the well back to producing and paying quantities. So there's a tension there between those two clauses. Other things to look for that landowners wouldn't necessarily understand is that there must be a completed well capable of producing in paying quantities before a lessee can declare a shut-in. I've seen them abuse this clause before. Some are trying to half drill a well, or drill a well without fracturing it, or drill a well, fracture it, but not know how much gas is coming out of it, and then declare a shut-in, perpetuating the lease, making the primary term last longer. In order to have a legitimate shut-in under a shut-in clause, there must be a well already producing in paying quantities, meaning that they could be selling royalties from it. And the law is pretty clear on that nationwide. Now, another wrinkle to this is, was the well completed after the primary term has already expired and then the shut-in was declared? Now, this is a rare situation, but sometimes it occurs, and the lessee then tries to claim that the lease is perpetuated using the shut-in clause. So, to be clear, if we are facing a situation where the primary term is about to expire, then the lessee drills a well, and the primary term is expiring, invokes the drilling operations clause so that they save the lease while the well is being drilled, that's fine so long as they get the well online and start selling gas or oil. However, if they then at that point invoke the shut-in clause immediately and the well is completed after the primary term, my opinion is that the lessee cannot do that. It's not been tested in Ohio, but it has been in other cases. I view that as an abuse of the shut-in clause, and there are other courts in other parts of the country that have held that way. So the bottom line is the lessee needs to be vigilant, that the lessor needs to be vigilant, that the lessee is not abusing the shut-in clause to make leases last longer than they should. Now again, this is a complicated topic. I've condensed this into just a few minutes. It fills chapters of oil and gas law books. If you're running into a problem where a lessee claims that the lease continues on beyond a certain point and invokes the shut-in clause, you need to get legal help. It's not a do-it-yourself project, and you need to find a lawyer that has experience in oil and gas. I've dedicated the last 4 years here in eastern Ohio during the Utica shale boom helping landowners facing situations in which the lessee claims that the lease has not expired when it really has. If you are facing a situation like this, particularly with a shut-in clause, please give me a call, 740-374-5346, or visit my website, www.fieldsdemlow.com. Thank you.